This courtroom showdown is anything but calm. A man breaks into a full-on Rambo tirade in front of the judge, demanding justice on his terms. But is he a desperate father? Or a flight risk with a long criminal past? You won't believe how this spirals.
Sometimes, sir, if you just talk to your attorney and close your mouth, that was done in far less time than it took you to go on your little ramble.
Well,
Okay, go ahead.
today,
Yeah, that's fine.
thank you. We're trying to get an offer on this file that Mr. Rainey will be happy with. Not yet been able to negotiate that with the people. I'd have to negotiation and try to get the offer that
You get that done by the second you want the name.
the second should be fine, Judge.
Probable cause conference, January 2nd,
Can I
2025.
Hey, Judge,
90.
can we I want to try to come to some kind of agreement today. I've already done 6 months on this case. You know what I mean? I came from one jail, got PR'd. They came and picked me up. I did my time over there and I only got a 3-month charge over there. They said they would release me earlier to a probation center. I didn't get to do that because you guys had a hold on me. I sat in there, then they came and picked me up after I got done with my 6 months, brought me here, and I've already sat for a month and have been adjourned twice now.
Listen closely. This isn't just courtroom drama. This man says he's done his time, missed out on probation, and now he's pleading for mercy to return home to his kids and dying dog. But does hardship justify chaos in court? What would you do in his place?
Okay.
I've never been,
I don't-
never been in any kind of drug charges.
Sir, hold on before you go on. I don't know anything about that. It would be a bit hard for a resolution to happen today.
I did a
My
by
understanding
mail.
at the last hearing, they were attempting to try to get mitigation information over to the prosecutor. If they got that over to the prosecutor, prosecutors are going to take that into account and trying to formulate some deal.
Because technically, it's
I
my
don't-
first drug charge via 7411. You know what I mean? I've never been in on any drug charges. I do have charges for like a CCW.
Sir, what do you want me to do?
I want to try to get this taken care of. I got a family at home that I'm trying to take care of. Or at least be able to get a PR so I could take care of my son myself. I've been locked up almost 7 months now. I got 3 kids at home. I got a dog that's about dying. I got a property that I take care of. I run a business. I just want to try to get some kind of leeway so I can take care of the stuff that I have to as a man. I don't have just family out there that can be just taking care of my properties, taking care of my job. I was a business owner. I went through a divorce and made some mistakes. I'm not trying to pay for it for the rest of my life. I'm going to lose everything.
Would you please take that, Judge, as a bond request on behalf of my client?
Any response from the people regarding?
Your Honor, in June of 2024, the defendant failed to appear and a bench warrant was issued. It appears that he was picked up on that in late November 20th, 2020.
So what happened with that? Let's stop there.
Sir, I left here, got picked up from Hillsdale County. They picked me up. I've been in jail ever since and then got brought here. I didn't skip out
Do
on
we
court.
have a showing? You know what? Chill,
Yep,
chill.
I understand.
Sorry, Judge. I did discuss this with my client. He did suggest that he was in Hillsdale County when that.
Here's what I'll do. Let me do this
Yes, Judge.
because you got to teach him how he addresses a court.
Yes,
I
Judge.
First of
apologize.
all, no, you're trying to force your way to do stuff. And I'm just going to tell you, you first of all were gone for a very long time from this court when I had it, and we didn't hear from you. So you might want to check how you're operating with me because I don't have to do anything on this case today.
I understand, sir.
So what I'm going to do is I'm going to pass it, take him back. Mr. Feaster, I'll give you an opportunity to talk with him, look at and see whether you can verify what information he's giving the court so the court can get his file.
Thank you, Judge.
Thank you.
Very much, Judge.
And see, sometimes, sir, if you just talk to your attorney and close your mouth, that was done in far less time than it took you to go on your little ramble tirade. Thank you. Have a good holiday. Your name, sir?
Michael Clapton.
And I know that's not your writing. You only filled out one green sheet.
Well, I'm going to ask for a prelim exam
Oh, you're asking for a prelim on
on
one.
one of the 2 charges.
So the 1529, you're asking for a prelim? Is that right? Unless I had the wrong. No, you're asking for a prelim on 652.
Yes.
So let's start with that one. Is discovery complete on that?
Yes. As far as I know, it is.
All right. People have their witnesses available the second? preliminary examination will be set in person, January 2nd, 2025. Emily, 9 a.m. before Judge Barr. Bond on that matter will continue.
May I address bond at the appropriate time?
Sure. You're going to want to address it on both.
Yes.
So let's do the other ones and then we'll have you address bond. On the other case, you're asking for an adjournment.
Yes.
What date did we give him the last time? You see, I can adjourn it to the 2nd at a different time, but your PCC on that one.
We're missing the search warrant on the second one. The one that I'm asking to be adjourned. So as soon as we get the search warrant, we'll be ready to go.
All right, so why don't I do this? Since you're coming on the 2nd anyway for an exam on that one, I'll adjourn the probable cause on this one to the 2nd because we're happen to be having them that day. 2025 at 9 a.m. Bond will continue in that matter. Well, you want to go ahead.
Yes, right now there's no bond for reasons I'm not quite sure on. He has a bond. He had a bond of $5,000, 10%. He was in here earlier, and basically he got afraid that they were going to ask for a $250,000 bond and left. But he has since turned himself in.
Oh, yeah, I did that.
I'm not surprised.
Yeah, you shouldn't be.
I'm not.
So he was here, did not appear for his proceeding and left.
Yeah, he left. Or
Yep.
Say Ypsilanti, he left home.
And I revoked his bond.
Yes.
Back.
And I'm asking for the
So
bond.
now we have him here.
He's here. His employer's here. Jonathan Hunt. He works full time for Mr. Hunt. Mr. Hunt, could you stand up so the judge can see who you are? I'm not making this up.
Hello. I believe that you're not making it up.
So I'm asking for a
He
relatively.
shouldn't have left. I mean, I'll
I
let you
agree.
go on, but he shouldn't have left. I mean,
I totally.
there is nothing really that I can think of that's going to indicate that he's a flight risk more than that.
Well,
But I'll let you go. Go ahead. What?
I've been retained. He's listening to me. He can be tethered to his job, tethered to his home, and that's it.
Response from the people.
Thank you. I am stuck on I am stuck on he turned himself in part. I don't understand that because he was arrested in Canton, Michigan.
I thought he turned
Oh.
himself in.
So not only did he leave here, he didn't then change his mind, come back, turn himself in. He got arrested. What was he doing when he got arrested?
He's innocent until proven guilty, Your Honor.
He is.
So when we were here in May, I told the public defender that I would be requesting.
Here's where it gets serious. The prosecution reveals the defendant's past, drug charges, weapons offences, and an active role in a statewide trafficking investigation. He didn't turn himself in. He got arrested. The judge is piecing together a bigger picture, one that's not in his favour.
$250,000 cash jury bond.
That's right.
The public defender went out to the hall to speak with Mr. Clofton to advise him of the same and essentially to prepare for their defense of that argument. Mr. Clofton ran. At the time that the case that he is in custody for with bond denied, at the time that he was arrested on that file initially back in July 2023, while he was being searched by the police and when the police found cocaine in his possession, he told the police, I have a warrant for my arrest.
That's what I meant by.
He knew that he had a warrant for his arrest and again, did nothing to resolve it. When they asked him, what do you have a warrant for? He said, just drugs. He has a criminal history that includes, sorry, I don't have it already pulled up in front of me, multiple drug charges, convictions. He also is the subject And I feel that I can disclose this because the search warrants have already been executed. He is the subject of an ongoing statewide trafficking investigation. I am meeting with the law enforcement agencies next week to determine where that case is going. But his criminal history in terms of drug trafficking begins in 2006, where he was convicted of delivery of manufactured controlled substance. He was sentenced to a juvenile. Again, in 2006, he was charged with delivery manufacturing. In 2007, he was convicted of home invasion in the 2nd degree. In 2011, he was convicted of fleeing in the 3rd degree. I could continue on, including 2020. He has convictions for firearms, including CCW, possession by a felon, RMO, and that is his most recent conviction, at least as far as I can see from his lien. And because he was out on a drug case with the bench warrant, knew of his bench warrant did not mean, and the ongoing investigation against him and his associates, I had planned to come in here and make an argument for $250,000 cash surety. Today, he should not get the benefit of that argument. His bond should remain denied. Your Honor.
Anything else, Mr. Benson?
Waiting to hear on the statewide investigation, but he's not charged with that.
Oh, I understand that, but I also understand that he was here, left, did not voluntarily come back or change his mind. We now have him. He's a suspect in other things. And he didn't turn himself in.
What?
He's a flight risk.
I mean,
Clearly.
they told the cops that, look, I got a warrant.
And did nothing. Motion for bond reduction denied. Bond will continue.
Despite the emotional pleas, the judge denies bond, citing serious criminal history and flight risk concerns. This case reminds us, in court, actions speak louder than words. If you found this case as shocking as we did, like the video, comment your thoughts, and subscribe for more jaw-dropping courtroom breakdowns.